Welcome back to the PI show. We're coming to an important segment called Kathy's Mailbag, and welcome back to the fifth series, Kathy. You're...
Have you renamed it, Harry?
No, it's Kathy's Mailbag.
This mailbag brought to you by Kathy.
Well,
I mean,
you've
I saw
seen
Viv
Viv
the other day. Yeah,
How
she's
is
looking,
Viv doing?
she's looking fantastic.
Good evening and thank you for having me back.
She's got a beautiful
firstly.
little daughter called Zara Christina, albeit tiny.
And
really
mother's
small.
healthy.
Yeah, very healthy.
She must be looking well though.
As exuberant and fast as ever.
Looks good.
She says she's got
Is
bags,
she
but I couldn't
proud
see.
mum?
She's beautiful.
Good.
Doing really well.
Well, we wish you well, Viv. And viewers, thank you very much for watching us again. And we'd like to welcome you to season number 5. And we'd also like to keep reminding you that we are here because of you, especially this segment. So please keep writing into us on thepishow.com. And we've got fantastic questions from you at the moment. And so we would like to jump straight into them. The first one, though, I will say is anonymous. And it says, to the PI show. In about November 2003, 2 dogs jumped to my fence and attacked me in my backyard. I was pregnant at the time and I lost my child as a result of the attack. I spoke to my neighbour and to a lawyer and sought counselling for this. My neighbour told me that they had contents insurance, but the public liability only covered them for injuries on their property. My lawyer told me that whilst I have a strong case, my neighbour was mortgaged to the hilt, and that my neighbour had no assets and that no insurance, and that I would get nothing. Recently, I found out that my neighbour's contents insurance covers them Australia-wide. I believe I was misled by my neighbour, or that the neighbour was misled by the insurer. My question is, can I now sue the neighbour? Now, Tony, would you like to answer this one?
Definitely got a claim. You got 3 years under the Wrongs Act to pursue the claim, and plus also it's a significant injury. Loss of a child or fetus definitely qualifies for significant injury. Claim would be for medical and like expenses, Harry, associated expenses, pain and suffering, loss of enjoyment of life. And this business about the neighbour being misled or misleading her, my view is that if you sue your neighbour, what would happen is the neighbour would get lawyers to represent her and they could join the insurer, her insurer, as a third party, Harry.
If they denied what's called an indemnity.
And I'm surprised that the neighbour hasn't been charged because, I mean, dogs are supposed to be secured and...
But the
Tony,
first...
sorry. My question to you, though, Tony, is given that it's November 2003, isn't that outside the statute of limitations?
Well, the legislation says when you become aware of a cause of action, so I think you'd get an extension of time, Harry.
It's arguable. On balance, I think that's right, but...
and you've got to show prejudice.
Well, you've got to explain the delay,
Yep.
so you've got to explain why you did delay, so she explains it by being misled, if you like. The lawyer maybe had given negligent advice, possibly.
Yep.
We don't know the full facts, but probably she'd get an extension of time.
Yeah, look, you've got to show, the defendant's got to show prejudice, and I don't think they would in this case.
So if the facts aren't really in dispute...
No.
On
this set of facts here, I'm reasonably confident she'd get an extension, and she's
extension
got
time.
a pretty good case.
It's a substantial claim.
And
on that
secondly, you'd be confident that the insurance should cover injuries that occur outside the home.
That's exactly right.
So the neighbour should be insured. So we think it's a viable claim.
I think it is.
So it's definitely worth seeking legal advice
I
on
would
this front
definitely
because
get legal advice.
on the balance of probabilities, you could have a claim. All right, well, moving on. We've got Mary from Croydon who writes in, Dear Tony and Harry, while my 10-year-old son was recently around at a friend's house, he fell from a tree. He had his leg broken and is currently on crutches. The doctor said it was a very bad break and we're concerned he may have problems in the future. Am I able to sue the parents whose house this happened at? We are very worried about our son and want to make sure he suffers no disadvantages in the future because of this incident. Well, Mary, Harry's going to answer this one for you. What are your thoughts on this, Harry?
Well, there's again a number of legal issues you've got to look at. Firstly, you'd have to see a photo of the tree and what condition the tree was in, how high it was, where it was located, and the reason why the boy fell. I mean, was he on his own? Was he pushed? Was he playing with someone else? And secondly, you want to see in that context the level of supervision of parents and whether the parents kept an eye on children in those circumstances. And thirdly, the you may have to wait till the injury stabilises, if you like. It's a broken leg, so you've got to see whether it's a significant injury. It should meet 5% whole person impairment for pain and suffering. The medical expenses and other sort of out-of-pocket expenses would be covered. But you still have to have a 5% whole person impairment. If the leg healed completely, then there's only a medical and like expense claim if you can overcome negligence. So look, there was a case in New South Wales that a boy fell off a bunk bed and he was injured and got a lot of money. I think it was overturned on appeal, unfortunately.
Harry, I think you can distinguish that with this case. I'd come back to the issue about level of supervision. I think that's the most important issue in this. And, you know, the other thing you kept saying is, what did they do with the tree? They might have had ropes hanging off it and they could have been using it to play all the time. So I think supervision's a massive issue in this case. And arguably there's a reasonable case depending on the extent of his injuries.
But whether there's a real risk in the tree itself, given its history, its nature,
well, if you
maintenance of the tree.
But
if you encourage them to go up on a tree and things like that, I think it's important that they have supervision, Harry.
But what about, I mean, with the extent of supervision, even if there was supervision but the actual boy was not
on a frolic of their own.
That's right, not looking at what he was doing or...
That raises other issues, but
I mean, that's also something for consideration, isn't it?
It is. Contributory negligence.
It is.
That's right.
But the starting point is supervision.
Very much. Yeah. Okay, well, we'll move on to the last question because we are running out of time. We've got a very interesting question this week, and it's from Fritz Polentz, who writes, Dear PI Show, I am a German tourist who recently came out to Australia with my wife on holiday. We rented a car to drive along the Great Ocean Road. To our horror, whilst my wife was driving, the car began to slide off a slippery road down onto a huge cliff. It flipped 5 times and landed 70 metres below. That's very unfortunate. My wife was bleeding from the head and our luggage was lost from the car. Do we have any rights to compensation? Okay, well...
Starting point is lodge a claim with the Transport Accident Commission.
That's right.
Both the husband and the wife.
That's correct. And you get your medical and like expenses covered and any other losses covered. The luggage you won't.
Well, that depends. If they're tourists, Tony, could be under a
different
insurance policy for travel insurance
travel
as well.
Insurance. That's correct. That's correct. But I think their biggest concern, judging by this question, is themselves.
That's right.
And if she's got a long-term psychiatric or psychological injury, because it doesn't sound like they've got any serious physical injuries, then she may be able to sue in due course. She'd need a serious injury certificate, Harry.
That's right.
But the husband's got to sue the wife, dare I say. Well, the wife was driving.
But that's if he sustained injuries, because it doesn't actually mention here about Fritz's injuries.
Well, both parties might have a claim because it sounds to me that the road was unsafe, so you might have a claim against the Highway Authority. Once you get a serious certificate.
That's possible, yeah.
But look, get advice because I think there's some rights there that you've got to...
You can still raise a claim, though, that's the first and foremost.
If the car's registered or... TAC will step into the shoes and look after the injury.
We're going to have to wind up the show, Harry and Kathy. Okay. It's been a fantastic show with Mark Dorman on board.
It was.
You, Kathy, and
thank you.
Harry.
But no, we should get Mark back because he was very, very good. And again, please, viewers, please write in because we love doing this segment with you.
Thank the viewers for watching us. And next week we're going to do the case about David Jones. So please tune in. Thank you.
Good night.